boom, you've just been in an accident, right? One of the first things you might be wondering is this insurance company going to be watching my every move? Hi, I'm David Carter from Carter Injury Law, and I'm going to explain how surveillance usually works when an insurance company is involved in a personal injury case. So whether it's a slip and fall or an auto accident, most of the time it's those kinds of things, right? If it's a wrongful death case, they're not going to be watching you. But if it's a personal injury case where you're claiming, hey, I've been injured from this, that likely they might watch you. Usually right at the beginning of a case, they're not going to put surveillance on you. It's very expensive, and the insurance companies don't want to spend that money on every single claim they have to, watch somebody, but potentially they can. So these are people that you might not even see them. They could be on your street in, a van that's like, looks like a painter's van, and they're in the back and they're videoing you. Most of the time when we see surveillance, it's in litigation. So once we filed a lawsuit against an insurance company and we said, hey, we're asking for a lot of money here. This isn't something, we're not asking for $15,000, or we're asking for a lot of money here. They're not gonna tell us, and they don't have to tell us, but they're gonna put surveillance on that person, follow them around. What you wanna keep in mind with surveillance is don't stop living your life because you think an insurance company might be watching you, right? If you go into court and you go to a deposition or a trial and you testify that, hey, of course I can still take my garbage out, and they get you on video taking your garbage out, to me, that's not the end of the world, right? You've admitted it. But what you can't do is say, oh, I can never take my garbage out again, and then they catch you on video taking your garbage out. That will destroy your case because you've lied under oath, and a jury will see that. So be very careful about what you say you can and can't do in a deposition, and make sure, because after that, your deposition, likely, yes, they're going to put some surveillance on you. They're going to be watching you. There are places they're not allowed to follow you. They're not allowed to invade your privacy. But when you're in a public place, they can watch you. So if you take your kid to the park and you're claiming I have really bad back injuries and you're pushing the kid hard on the swing, they're likely going to show that to a jury. Or if they see you moving, if you move your house, this has happened in a few cases, right? You move your house and you're picking up big couches. Even if you say, hey, look, I moved, I can pick up couches, that's something they're going to want to show the jury. So just be careful. If you're at a public place, they can record you. The biggest modern thing we're seeing with surveillance is actually social media surveillance. So the days of the guy following you around with the old rusty van and photographing you, that still exists, and those companies are still there, and the insurance companies still use that. But on almost every case, they're looking at your social media. So that is the surveillance that I think is very important to focus on at the beginning of the case, because that is completely within your control. The first advice that I give to clients is to completely deactivate social media accounts, right? While your case is going on, just deactivate them. Then you're not tempted to post, you're not tempted to do it, nobody can post pictures of you, nobody can tag you in pictures, and that way, the insurance company can't see it. Because believe me, even if you have your profile set to private, and as private as it can get, they have ways of getting to see your profile sometimes. And even if they don't, if you file a lawsuit, a judge could order that you have to turn over everything that's on your private profile. It doesn't seem fair to me. It seems like an invasion of your privacy, but some judges have ruled that, yeah, the defendant gets to see all that stuff that's on your social media. So if you're not willing to deactivate your account, the second thing I say is just lurk, right? And what I mean by that is just only keep your social media active. Don't let anybody else tag you in photos. Put it on the setting where you cannot be tagged in photos. But you want to watch other people's posts. You want to see your grandkids, or you want to show your you want to see what your cousins are up to in Wisconsin, right? Okay, fine. You can lurk, you can look at their posts, you can private message people. I think we have a decent argument that those are, you have an expectation of privacy in those messages that the defense can't get, but don't post anything. Don't even post anything on their timeline. The next thing is some people aren't even willing to do that, right? So they're like, no, I have to post on social media. I have to post about I love Donald Trump or I love Joe Biden or whatever it is, right? A lot of people are very into posting about politics. So if you have to post, only post things that are not pictures of you and not related to the case. So politics is fine. I prefer that you don't do it. I prefer that you not give the defense any ammunition at all. But if you have to post, and you can say happy birthday to people and things like that. But the absolute thing that you don't want to do is to post pictures of you mountain biking, you rock climbing, you playing tennis. Even if you can do those things, if they ask you for a deposition, you'll testify. Yeah, I can play tennis. I have played tennis. Yes, I can. But why give them the ammunition of having photographs of you doing it, right? That's free That's free money for the defense that you're giving them and putting them back in their pockets that they would otherwise pay you on the claim. You're giving it to them for free, and you're not really getting anything out of it. So that's the biggest kind of surveillance I want you to focus on at the beginning of a case, and I tell my clients to focus on is step back from social media. Don't post anything. And then, yes, the insurance company will be watching you at some point if your injuries are bad enough and the insurance company determines that, hey, this is a case worth doing surveillance on, then they might do that. Now, they don't have to tell us about it again, but before we go to trial, if they're going to use it as an exhibit, we have what's called an exhibit exchange, and they have to file an exhibit list. At that time, we will know if they have surveillance on you. Sometimes we go into mediation and they're like, hey, look, here's the surveillance we have on your client. This is why your claim isn't worth as much money as you think it is, to try to settle the claim. But they don't have to tell us about it then anyway. They have to tell us about it when they file their exhibit list and, say, look, I'm going to use this as an exhibit at trial to impeach your client or just as evidence. So watch out for those surveillance people when you get in an accident. If you have any questions about that, if you wonder, I've been in an accident and I think I'm being followed, call us. I'll walk you through what to do. If you have questions after an accident about, hey, I run my business on social media, I can't stop posting, what should I do? We'll give you advice on that too, because we do have clients that earn their living off social media, whether it's selling a product or whether they're, like a personality that generates revenue for them. We can guide you on what to post and what not to post, and kind of walk you through those landmines, because an insurance company will eventually see it. So we offer a free confidential case evaluation. Even if you just want to call us and say, hey, been in an accident, what do I do with my social media? We're happy to answer those questions for you for free. Call us today.